Yes. Why? Who's the senior? Miss P. Chakrabarti. Who's for the other side? Yes, yes, spoke. Have you informed the other side? What is your name? Huh? Miss M.S.K. Khan submits the praise for adjournment on the ground that senior Miss P. Chakrabarti is having some personal difficulty. She also submits that she has taken the consent of the other side. So, it is noticed that the present case had been fixed as part heard. However, no order has been issued by this court making this case as part heard. On the prayer of Ms. K. Khan, this is the matter after. This is the matter after the week. Yes. Okay. Counsel for the petitioner. Respond number. Respond number 4. Adjournment prayer has been made on behalf of Mr. P. Kalita. On behalf of Mr. A. Bhattacharya, learned counsel for the respond number 4 on the ground that he is bedridden due to a leg injury. So, thus, Miss P. Podar. P or P? P. Podar appears for the petitioner. The case is adjourned for a week. For a week. Who's for the other side? Okay. But the issue is very small. No, the record, what we need is only maybe 1 or 2 pages. So then let him be there on the next date. Let your officer be there also. Because he will know which pages to turn to. Work order, there's no stoppage of work orders. There's no. Okay, so we will clarify that. We'll clarify that. Right, on the prayer of Mr. Arjar, who submits that he needs to be briefed on the basis of the records which have been brought. List the matter on. When do you want? 12. 12. List the matter on 12. First up, Mr. B. Sharma appears for the petitioner, while Mr. D.K. Nath appears for the private respondent. It is made clear that there is no stay order passed by this court, and as such, there is no stay order. It is made clear that there is no stay order passed by this court, and as such, there is no embargo on issuing any supply order. Actually, it cannot be to the petitioner. It's going to be this way. Anyway, they want this order. How does it matter? Item? Okay. Yes. Non-disbursement of subsidy has come to this court also many times. Yesterday also I was dealing with it. Yesterday also I was dealing with a subsidy matter. Why is it a bench 5 matter? Dr. Saraf was arguing before yesterday. I disposed of one case, subsidy matter. Why? This is a subsidy matter. What do you mean it's a bench 5 matter? It's not a bench 5 matter. Who are you trying to fool? Were you here yesterday? Huh? You were not there. I thought I saw you also sitting. Huh? This side. You think this is a bench 5 matter. What's your name? Huh? Anandata. We'll take it up. Next. Item number 30. Okay, right. Adjournment prayer has been made on behalf of Mr. D.K. Mishra, learned senior counsel, who is apparently in hospital. Accordingly, this matter after 4 weeks.
Item 35 for withdrawal.
Mr. H. Betala, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition. Who is for the other side? No one. All right. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn.
One for admission.
Wrongly shown us.
Item 1.
No, item 6 also, I think. Correct. For what? So what is the specific amount of remission? You have not got the instruction. What is the instruction? And what about but there are two parts to this writ petition. One is the challenge to the termination. Then on that, so what do you want? Huh? Then what is wrong with the termination? Mhm. No, but then that does not give you a right to continue with a lesser. They will consider your remission amount. That's all. no, you see, if you cannot, you have given a certain bid amount. Now you have not been able to pay that amount. Reasons might be correct. Reasons are correct. Accordingly, they have granted you remission. So they are going to now they are going to now state the amount that for the amount of concession being given to you. So that will be done. That is one aspect. Now, with regard to the second portion, termination, there's nothing wrong because you have not been able to pay the amount for correct reasons, no doubt. So that tender, in as much as it has become infructuous in a way. I mean, not workable. So let the fresh tender be made and let the correct when at two. He wants at two. He can give at two. What is this letter? I do not know. No, it's in the vernacular, then I cannot read. So what does it say? Okay. So you want instruction. Okay, right. When can you give so when do how much time do you need for Thursday? Not Thursday, no. Too many. Huh? Next Monday? Monday is okay. Okay, right. Um, Mr. P. Sharma, Learned Counsel for the AFDC submits that he will obtain instructions with regard to the specific amount of remission approved and granted by the AFDC. By the next date. Mr. Huh? M. Khan. Mr. M. Khan, Learned Counsel for the petitioner submits that he needs time to obtain instructions from his client with regard to the letter dated with regard to the statement made by the petitioner that statement made by the petitioner at the time of hearing before the managing director AFDC, that he would not be able to operate the fishery at his bid amount, at his quoted bid amount. Accordingly, on the prayer, the parties list the matter on 11th. Ah, the no registry that registry. Uh, no, full stop. This case has not been fixed as part heard by this court, as can be seen from the various orders issued. As such, registry to make correction of the same.
Item 7 to 18.
Yes. Huh? Why? What is the matter about? What to do? You are not ready. This matter is of 2019. Right, on the prayer for adjournment made by the petitioner's counsel, which is not objected to by Mr. H. Barwa, counsel appearing on behalf of Mr. B. Chowdhury. Standing Counsel for the Finance and Taxation Department. List the matter after a week.
Item 19.
What election? Huh? So when is that model code of conduct being, when will it expire? 13th of November. Okay, right. Mr. P. Sharma submits. Mr. P. Sharma, Learned Counsel for the Fishery Department, submits that in terms of the letter dated 4/11/24 issued by the Deputy Secretary to the Government of Assam, Fishery Department, formal order of settlement of the fishery cannot be issued in view of the model code of conduct being implemented in Nagaon district for the by-election to be held on 13/11/2024. Accordingly, leave this matter on. Huh? Why? Okay, list the matter on second, 2/12.
Item 20.
Acha, no one appears for the petition, are you right? Yes. To what effect? To what effect? So what is the decision there? What has it been? What has been stated? No, no, audit objection, okay. Let me see. Yeah, para was coming. Correct. The 16 lakhs, so that can be recovered some other. Yes, suppose. Correct. You see, your only problem is with regard to the 16 lakhs. So minus the 16 lakhs, you give the remaining. That's all. Yes. Yes. Why should we ask them to file an affidavit? Let them file an affidavit. It'll be better for you also, I think. Because at least you'll have something. Then they cannot, resile from their averments, mate. Right. Miss J. Gogoi, learned counsel for the respondent 4 and 6, submits that she has received parawise comment dated 5/9/2024. No, issued white letter dated 5/9/2024 by the executive engineer PWD. That's the comma, which states that out of the remaining security deposit payable to the petitioner amounting to rupees 54,94,071, rupees 16.55 lakhs is under audit objection raised by the accountant general audit, Assam, pertaining to deduction of forest royalty, VAT, and income tax. Ms. J. Gogoi submits that she will be filing affidavit within a week. Accordingly, leave this matter on. Give a date next week. Huh? 12th. Huh? 12th. You fix it, you file it by this week, madam.
I think 21.
Yes, what is your case? Huh? Huh? There is a criminal case also. MECT case. There is no police case. What do you mean subsequently turned into a? How can a police case be turned into a MECT case? Huh? Page 26. What do you mean by law? Huh? Blacklisted? Who is blacklisting it? Blacklisted by whom? This is by the blacklisting under what provision? No. You see, if you're going to blacklist a vehicle, under what provision can it be blacklisted? Under what? Please educate me. Please enlighten me. Under what provision of law can a DTO blacklist a vehicle? Can you can you can you can you can you pass an order which is not provided for? No, before that. No, this is not transfer of ownership, madam. Anyway, Mr. Counsel, your vehicle was involved in an accident, correct? Someone died or what? Injured. Then It has been locked by the DTO. Now, where is your letter to the DTO asking for release of the vehicle? Where is your letter to the DTO asking for release of the vehicle? No, no, Mr. Counsel, you have stated, so you have not submitted any letter. And instead of submitting a letter, you have come directly to this court. You go and avail of the alternative remedy first, you go there, and then if it is denied, then you come here. Mr. Counsel, first of all, Mr. Counsel, first of all, where is your letter, your representation? Where is your submission? Let us see your averment that you have submitted a representation. Approach and writing a letter is different. In the Act, section. Okay, madam, one thing. This locking was done on which date? Accident occurred on 20 December. 20 December 2023. Correct? Accident. Now, where is your notice sent to the owner? Yes, you go to the authorities asking for release. Whatever it may be not received, you have not also gone there. You have you have not received, neither have you written a letter to them. You have come directly here. Heard, Mr. M. Ahmed. M. Ahmed, learned counsel for the petition. And Ms. M.D. Bora, learned counsel for the Transport Department. Comma respondents number 1, 2, 3, 4. Full stop. Mr. S.S. Roy appears for respondent number 5. The petitioner is agreed by the action of the respondent number 3, who has locked what? Who has locked the vehicle? Who has locked the vehicle? Who has locked the petitioner's vehicle bearing registration number AS-19-AC-4338 bracket Tata. What vehicle is this? Uh, this is bearing number sensor, huh? 4338, which had met with an accident on 13/11/2023. No, no. When did the accident occur? 13/11. 13/11/2023. Good stuff. Which resulted in an injury being caused to one lady, that is Srimati Ramadas. Full stop. As a consequence of the vehicle accident, Bongaigaon PS case number 497/2023 under section 273/337/388 IPC. was registered with the Bongaigaon police station. The injured lady also a claim registered as filed a claim before the Motor Accident Claims Tribunal Bongaigaon, which was registered as MAC case number 365/23 under section 166 of the Motor Vehicles Act, 1988, claiming compensation on account of the injury sustained by her. The petitioner has approached this court with the prayer that the locking of the registration of the vehicle, petitioner's vehicle, should be set aside and the vehicle should be released to the petition. Ms. M.D. Bora, the learned standing counsel for the Transport Department, has submitted a letter dated 4/11/2024 issued by the District Transport Officer in charge, I/C, in charge, Barpita, which is to the effect that but why should Barpita, this is Bongaigaon. Oh, okay. Okay, by the actually not respond number 3, by respond number 4, you're right. By respond number 4. Wherever we have said 3, make it 4. Then what have I said? That as per the official records, the petitioner's vehicle has been blacklisted by the DTO Bongaigaon. However, the seized vehicle has been seized by the office of the District Transport Officer Barpita. Though notice had been sent on 3 occasions to the petitioner, no response has been received from the vehicle owner. The Standing Counsel for the Transport Department has also submitted the 3 notices dated 20/05/2024, 25/6/2024, and 31/7/2024, issued to the petitioner asking him to requesting him to compound the motor vehicle offence case by e-challan number AS 13796824012 31722241/23/01/24, and to take custody of the seized vehicle from the office of the DTO Barpita within 7 days from issue of this notice. It further states that failure to compound the offence within the stipulated time under Rule 109 bracket A of the Assam Motor Vehicle bracket Amendment Rules 2023 would result in the seized vehicles being disposed of through public auction under the district level committee Barpita for auction of seized/confiscated vehicles. I'll give you the number once more. AS 1379682401231722241. Okay. /23/01/23. Yeah. This para. I have heard the learned causes for the part. No, just right. Ms. M.D. Bora submits, next para, that the petitioner has not approached the district transport officer, office of the district transport officer, Barpita, with regard to the, as well as the DTO Bongaigaon, with regard to the seized vehicle, seized / locked vehicle, till date. I have heard the learned causes for the part. On perusal of the writ petition, this court finds that no, the petitioner has not annexed a copy of any representation submitted to the respondents for release of the vehicle bearing number AS 19 AC 433, which implies that the petitioner has not approached the respondent authorities for release of his vehicle prior to approaching this court. Next para. The letter dated 4/11/2024 and the notices and the three notices dated 20/05/2024, 25/6/2024 and 31/7/2024 are made a part of the record and marked as Annexure X collectively. A perusal of the above letter and three notices shows that the petitioner, it shows that the vehicle was subject to release. No, shows that the vehicle was to be released subject to compounding of the motor vehicle offense committed by, not committed by, involving the said vehicle. However, as the petitioner has not approached the concerned authorities, no further action could be taken by the state respondents, In view of the above facts, this court is of the view that the petitioner should first approach the concerned authorities by submitting a representation to the respondents number 3 and 4, for release of the vehicles as per law. As there is an effective alternative remedy available, this court is not inclined to proceed with this case any further. The writ petition is accordingly given the liberty to approach the respondents number 3 and 4 for release of his vehicle. The writ petition is accordingly disposed of. Who is he? Who is fine? Why? What is to be done by him? Nothing is to be done.
22.
Thursday, no chance. Because we have got Mr. P.K. Goswami and all, they're all ready. They're going to take the whole afternoon, whole day. What to do? Correct. I know. Okay, when do we fix? Thursday, I don't think. Because Thursday we can. Huh? This Thursday, no, not all. That Mr. Goswami's case. That is. We have fixed the 4-part hurt matter. 20th of. No, that is the court proceeding. Huh? That's what. No, 7th. There'll be no chance. Once it starts, I know. They're going. No, I know. Unless, of course, there is some adjournment due to some other thing, it is not going to be possible. The petitioner has not even completed his arguments, and we have got two senior counsels on this side who have said, one said that he'll take at least 2 hours. Friday? Friday?
That is scheduled on Monday. Assuming it is not possible. Yes. Take over to some. This, we can take another. Okay. And your option, already finished. Your option, we don't know. There will be on Monday, if you have something, try to build it. In any case, it might take some time. Follow us. Okay. So we'll start on Monday, because depending on both parties.
Monday, how many have we fixed? No. Not so. And then I sit here all alone. Because you see, we are fixing cases so that, because then I have to read also again. And, yeah. So I don't know. We can try on Friday if you want.
Only understanding Friday my you will also take some time. But let us because Friday will start.
Friday? This is on Friday? Is it okay? On the prayer of the parties, this is a matter of Friday. Interim, what to continue to that?
Orders item 23 to 26.
Let us see your papers that you have received. Who is the main respondent? By whom? So by Mr. Dinath. How much is the amount payable? 3 lakh something. I know, but in the first petition, how much? Small amounts. These are then
We have five completed. One,
when was the work completed? Prior to 2018, work completed, and the amount is an admitted amount, and you have still not paid. So you're not cooperating. That's your problem. Who is rejecting? Yes. Mr. Counsel, this court has ordered, directed the Hills Area Department to allot necessary funds. Okay. Now, if you think that this order is incorrect, you file an appeal. But as long as this order stands, then it is your duty to allot the necessary funds to the NCHAC. Now, if that is your stand, give me your stand. I will. Let me see what has been written there. That if that is your stand that you cannot do it, then contempt will frame charges against the respondent. Let him go to jail now. Mr. Counsel, there is a direction passed by this court. Yes, where have you said? Have you filed affidavit? When did you receive the instructions? 16th March. And you are not filing. This amounts to total willfulness. No, you're not filing. You don't want to file. You're only delaying the matter. We'll take it up now. Let him come. Let him free, let him answer why he should not be sent to jail. No, I'm not on that. I'm not on that. This court had directed you to arrange the funds. Now, when you say that you're not you're not you cannot make the funds available, then no, I don't think so. I think you have been playing around with this court since 16th March 2024. And you have not filed any affidavit for the last how many months? No, I'm not saying no. Right. What? For what? Huh? It's very clear for me. You're not filing any affidavit. Right, Mr. S. Borali, learned counsel for the petitioner. Also heard Mr. Dinath for the respondent number 1 and Mr. Miss for respondent number 2. This contempt petition has been filed due to non-compliance of the order dated 27/1/2023, passed in WPC 3674 of 2018. Para 5, 6, and 7 of the order dated 27/1/23, passed in WPC 3674 2018, states as follows. States as follows. This is at page 15. Okay. So, next para. Mr. Dinath, learned counsel for the respondent number 1, submits that since the matter relates to, submits that in terms of the para-wise comments received from the secretary to the government of Assam. Wait, just a moment. Received by the secretary to the government of Assam. What is this? Hills Area Department. Hills Area Department. The Hills Area Department has no comments to make on the matter, as the matter relates to the PHE department under the administrative control of the NCHAC, AFLO, as PHE is a transferred subject. The para-wise comments at para 2 states that HAD, the Hills Area Department, is not responsible for non-payment of work executed by the petitioner. Next para. This court has noticed that the para-wise comments had been sent to the counsel for the respondent number 1, while letter dated 16/3/2024, issued by the secretary to the government of Assam, Hills Area Department. Today, till today, that is 5/11/2024. No affidavit has been filed by the respondent number 1, despite the para-wise comments having been submitted, having been issued more than 7 months back. It is also noticed that subsequent to the letter dated 16/3/2024, this case has been listed before this court on six occasions, on seven occasions, including the present, including today. Next paragraph. When this court, in the order dated 27/1/2023, passed in WPC 3674/2018, has specifically directed the Hills Area Department to allot necessary funds to the NCHAC as per the requisition made and reiterated by communication dated 20/01. No, this is, dated 20/01/2021 and 13/04/2021. It is surprising that parawise comments have specifically stated at para 2 that the Hills Area Department is not responsible for non-payment of work executed by the petition. So, stop. Next para. The above, in the prima facie view of this court, amounts to contempt of court and flies in the face of the order passed in the writ petition. Flies in the face of the direction passed in the writ petition. Accordingly, this court is of the view that the respondent number 1, who has not found it fit to file an affidavit in this contempt petition till today, should appear. Huh? For what? When you have taken a decision that you all are not going to fund the money, well, that's all. Nothing is to be decided. With what? What have I said? In this contempt petition today, yeah, yeah, should be should be dealt with in accordance with the Contempt of Courts Act, comma, the year. It's the year. So, next para. It is also noticed that this court, on the last date, that is 28/10/2024, had given a last chance to the respondent to file their affidavit, failing which orders including personal appearance of the respondent / contemnor, if needed, would be issued. So, sir, as stated in the foregoing paragraphs, the respondent number 1 has not deemed it fit to file any affidavit. Till date, besides showing the intention of the respondent concerned not to act upon the direction passed by this. Huh? To do what? What will you do? No, you tell me what you're going to do. You'll do what needful you'll do. You see, this is not a question of this is not a question of you giving some legitimate reasons for not being able to comply. It's not your case that it is not implementable. It is your case that you are not going to do anything. What more does this court want? Full stop. Next para. Though this court is of the view that charges should be framed against the though this court is prima facie of the view that charges should be framed against the respondent for non-compliance of the order passed in the writ petition. In view of the prayer made by Mr. Dina, who submits that he will take this matter up with the respondent number one, immediately lists the matter on Friday. This is the matter on Friday. In the meantime, the respondent number one should file his affidavit by Thursday. Miss next party, right? Miss Ardeka, counsel for the respondent number two is granted 2 days time. 2 days time to file affidavit on the other respondent number. This is the matter of Friday. I think all the parawise comments involve all the four same. The parawise comments are the same. And let me see the parawise comment. Okay. This is with where the parawise comments to the others. Let me see. Let me see. All of them. All same date. Unpleasant, but sometimes we have to we have got to be, we have got to pass some orders which we do not like. And please tell him, I hate to do it, I have to do it. If he doesn't comply. Item? What is the matter about? Huh? Railway vending matter. Have you got any case? Otherwise, no. Then what remains? Nothing is different. Huh? Your license was your access expired when 2015. When? When did it expire? 2015 expired. Now the 2017 railway policy is there. Doesn't permit extension. Tender will have to be floated. So what are you praying for here? Huh? No, what is the background? Legal heirs. Can you inherit? What does it matter? Commission under what act? Under what policy? Commission vendors under what policy? 2010 policy was there. Do you have a license under the 2010? Now he's here. Yes, sir. Huh? You've got no right. Huh? No, there is the latest judgment of the Supreme Court where he has been given time till 27 December, I think, or 24 December. Only that. Nothing more can be given. On the basis of the Supreme Court order. Yes, give me. So what to do? No, no, not this. Where is the Supreme Court order dismissing the SLP? Original case, I know, but so the decision of this court has been upheld up to the Supreme Court. Yes. So this one, have you got this one? The Supreme Court order? Yes. Give it to him. Show it to this. You see that? How does it matter? You have to come under the 2017 policy only. Then, so we should we give them till 24th December or what? I know. Because in one case I have given on the basis of the Supreme Court order. They have to furnish an undertaking. Without undertaking, it cannot be done. Okay, heard Mr. M. Chetia, then counsel for the petitioner. Also heard Mr. B. Chakrabarti, then counsel for CGC for the respondent. The Do I have to mention everything? Okay, right. The petitioners who are the legal heirs of the commission vendors of New Tinsukia Station have prayed for setting aside and quashing the letter dated 18/4/2018 issued by the respondent number 5 on behalf of the respondent number 4. Directing the petitioners and their predecessors to remove their stalls. The petitioners have also asked for transferring the licenses that were issued to their parents, correct, parents, predecessors, in terms of no, that had been issued in terms of earlier one. This is in terms of the railway policy 2010, is it? In terms of, uh, don't say in terms of cut, don't say in terms of, in terms of you cut that part. Okay. So start. Next. So the petitioners are all above 60 years. So there's no question of absorbing them. So that's finished. So only the stall. So stop. The petitioner's case is that as they are running stalls in the railway land for earning their livelihood, they should be allowed since a long time, they should be allowed to continue running their stalls slash vends VNDS in terms of the catering policy. What is it called? In terms of the huh? In terms of which policy? Huh? In terms of the catering policy of 2010 and 17 and 2017. Naturally, now it's 2017, 2010 is gone. Next. The petitioner's counsel submits that though the catering policy of 2010 has been replaced by the catering policy of 2017, which does not provide for extension of the period for running the stalls slash vends, the petitioners should be allowed to run their stalls slash vends in terms of the catering policy of 2010. Huh? No, I think that's enough. No need of, there's no point. Mr. I mean, that's your only case, I think. Correct. The petitioner's counsel submits though the period for uh, though the period of running the stall slash vent by the petitioner has expired, comma, the petitioner's cases should be considered for extension of their for extension of for no for running the stall slash vent for a further period in terms of the catering policy of 2000. Next para. Mr. B. Chakravarti, the learned counsel for the respondents, on the other hand, submits that the present case has been that the present case is covered by the judgment and order dated 29/4/2022, passed in WPC 6473 of 2013, and the order dated 31/3/2023, passed in WPC 1828/2023. Correct. He further submits that the order dated 31/3/23, passed in WPC 1828/23, has not been disturbed by the division bench of this court in WA number 124 of 2023, which was disposed of on 11/3/2023. Full stop. The challenge made to the judgment dated 11/3/2023, 2024, passed in WA number 124 of 2023, was dismissed by the Supreme Court in the order dated 25/10/2024, passed in SLP C 17338/2024 and 23728/2024, wherein the petitioners were granted time till 27/12/2024 to vacate the railway lands, subject to an undertaking to be given by the said persons stating that they would vacate the premises on or before 27/12/2024, besides clearing all rent slash dues, if any, and not creating any third party rights. Next para. I have heard the counsel for the I have heard the counsels for the party. The facts of the case is that the petitioners were not given any licenses to operate the vents/stalls, though their predecessors had been given licenses. Correct. Were given licenses to run the stalls and vents on commission basis. On commission. Correct. Okay, what have I said? This okay from the beginning. Just say the facts of the case is that the predecessors of the petitioners were allowed to run their stalls/vents on commission basis, and the petitioners who are the legal heirs of those commission vendors were given temporary license, which has expired, on when? That much I know it has expired, huh? 2000? Expired in the year 2000. Huh? No, for all of them. For all of them, when? Mr. Council, my question is very simple. Don't give me the entire, just tell me when it was expired. In the year 2015. 2015. Full stop. The catering policy of 2010, which provided for operating stalls/vents within railway lands, was replaced by the catering policy of 2017. There is no provision for extension of the period for operating stalls and vents beyond the time period provided for operating stalls and vents on railway land in terms of the catering policy of 2017. The challenge made to the catering policy of 2017 while WPC 5313/2017 was dismissed by judgment and order dated 24/1/2023. And the same and the challenge made by WA 47 of 2023 was also dismissed by the division bench of this. The special leave petition filed against the judgment passed by the division bench in WA 47 of 2023 was withdrawn by the appellant in WA 47 of 2023. comma, without taking leave to file afresh, and a review was filed against the order passed in WA 47 of 2023 before the division bench of this court, comma, wide review petition number 117/2023. The review petition was thereafter dismissed by the division bench of this court. As such, comma, as on date, the judgment of the division bench of the High Court affirming the decision of the single bench shows that the catering policy of 2017 remains valid. Further, when you take this para 9, para 10, para 11, okay. Para 12, of this WPC 5598 of 2024. The order dated 30/10/2020. And next, accordingly, the petitioner shall vacate the railway lines in question on which they are operating their stall/bench on or before 27/12/2024. The writ petition is accordingly disposed. Everything is there in this para 12. Actually, in this para 12, para 12, the last portion, and they would have to abide by the direction passed in terms of the impugn notices dated so and so. This you cut. Okay, this. So, okay, those 23/10/24. In the wait, sorry. In I 3087 actually. Okay, so instead out here is 23/10/24 in the last in para 12. Don't change anything. Instead of this 23/10/24, you make it 23/9/24. Okay, 23/9/24. And what about this I? Is there anything here? Same date. Then these two I's can be disposed of. How many I's are here? Then you write into the order passed in the writ petition. The I's are also disposed of accordingly. So you want this back? Okay. Okay, you print it out and you give. I think you can take it. No? Miss again. Miss, you are appearing for whom? For Miss Agayan. You are appearing for point number 1. And are you filing any affidavit? Then you are talking about Miss A. Gayan. Huh? She's in the case. You are not in the case. Okay, so on her behalf, you're paying. Okay, right. What about you? Are you filing anything? Huh? Not yet, though. I know. I said, are you filing anything? Huh? But are you going to file? Miss A. Gayan, learned counsel for the respondent number 1, comma, Mr. D. Day for respondent number 5 and 6. What about you? Are you filing anything? Are you filing anything? No. Huh? Yes, no, what? No. Are you filing anything? Okay, Mr. D. Day, no counsel for respondent 5 and 6. Are granted 4 weeks time to file that affidavit in the position. Mr. N. Kalita for respondent number, he submits that he will not be filing any affidavit. Mr. DJ Barwa appearing for respondent number 4 submits that he has not received a copy of the writ petition. You give it? Submits that. Don't say has not received. Submits that he has received a copy of the writ petition today. And accordingly, he needs time to obtain instruction. List the matter after 4 weeks. Give it. Huh?
I think 22 for year.
Huh? Who heard the matter? I heard the matter. Yes. To what effect? What is what? Naturally, it has to be market value. No, government value. No. Who is for the government? Huh? Why? Who is the senior? Here's data. Where is he? Which court? What to do? No. This is a long matter. Huh? Earlier widow or BDO? So what? So what? No. No. Sorry. You don't have BDO will you see, it is not Mr. Chakrabarti or it is not Mr. Hawk or nothing like that. A BDO is BDO. It is not a contempt case. One BDO has submitted his affidavit, it will be the affidavit for the subsequent BDOs also. What kind of a submission is that? We'll list it tomorrow. Be ready. Why? Where is he? He's not coming this week. Why? He was some eye infection. How do you know he's got eye infection? Huh? How do you know? How do you know he's got eye infection? He came yesterday and told you he's not coming tomorrow because he's going to have eye infection tomorrow. Then why do you say he's got eye infection or something? He told you. He came and told you what? Tell the truth. Tell the truth. He came yesterday, left only just and you. How does that happen? So he hasn't spoken to you. Then he hasn't asked you to take a adjournment. When? When did he ask you to take adjournment? Who has asked you to take adjournment? Who is the other senior? Who is the other senior? And Bora has told you to take adjournment on behalf of Mr. S. Datta. Why did N. Bora tell you to take adjournment just like that? What did he tell you? Why? Huh? Okay, we'll list it tomorrow. No problem. Right. What is your name? Mr. A.K. Ghosh. Please for adjournment on behalf of Mr. S. Datta, National Counsel for the PNRD, on the ground that Mr. S. Datta is not available in the court today. Mr. A.R. Sikdar appears for the petitioner. List the matter tomorrow.
And 34.
Who has expired? Respondent number 2 and 3. 2 has expired. Okay.
People find that one.
Do them.
Level 9 of the key. Can you drop off the fire? But I think
You are appearing for whom?
online
Has been picked. Now the remaining will depend upon the facts of the final decision to be made. Okay, right. Mr. L. Sanktam appears for the petitioner. Mr. S. Chakrabarti appearing for the respondent number 2 submits that the respondent number 2 has expired on 11/9/2019 and due 2024 after 5 years. Okay. Yes. 11/9/2019. He submits that he will provide the details of the legal heirs of the respondent number 2 to the. Why don't you make an application? Why should you? You can also substitute. This is a writ petition. It's not, you can also do it. This is a writ petition. Why do you want to do it? Why? Huh? Correct. Maybe. Maybe. Then we'll close the writ petition. You'll make a loss. You're not interested. I do not know why is it so difficult for you to file an application. Why does it say that only he can file an application for imprisonment? So where why? Yes, show me. This is a writ petition. This is not a CPC. But how does it at the High Court rule? You cannot do it. The legal heirs of the deceased cannot file an application, is it? Correct. So what is wrong? So I don't know. Lera, you show me at 2 o'clock. Okay. And then just show me at 2 o'clock. Read petition, not CPC. At least I will learn something. 2 o'clock. At 2 o'clock. He says 2 o'clock. Or we can sit prior to that also. When? Huh? Yes. Just give me. I go to. Yes. Yes. Number 3. Yes. Yes. Minors. This for minors. Including mine. Yes. 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 Give me CPC. Yes.
And my lord, the property.
Where does it say that?
Why? Why say the plaintiff was ignorant of the date and not of that with the make an application. So normally, the plaintiff go for the.
But you're the petitioner.
Oh, I-
See that?
Now, then, but it means it gets debated. Now,
Ah.
we'll see the-
Correct. There are no limits. No. My question to him was, why can't he make an application? That's what I'm saying. Because if it's that's what I said. If since it's a writ petition, why can't he say that since so has died, my father has died. Let me, I may be allowed to substitute. No. How whatever. This is a writ petition. This is not a. There's no question of defendant or plaintiff here. CPC does not apply. The CPC, the records of CPC will not apply strictly in a writ petition.
In that case, my lord, under the High Court rule,
No. But this.
Application for substitution under the High Court rule, chapter 4,
Uh,
say under order 20.
come to the page 358. Yes. Have you got the same book? It says here, applicability to writ proceedings. Provisions of Order 22 are not per se applicable to writ proceedings. Bal Mukund Arora versus State of Rajasthan. Yeah. So what? That's what I'm saying. You see, that's what I agree. CPC, you have got to follow this. But in writ petitions, it's only the spirit. It's only the spirit. So there is no bar, according to in my view. That otherwise, why should this High Court rules also contain this? Provisions of Order 22 are not per se applicable to writ proceeding. In this CPC you have given me. Oh, I thought the CPC, yes. Anyway, this is let us go to the High Court rules. Yes.
High Court rule, chapter
Page. Yes. Yes.
of part, including minor.
Uh,
What the next time, what's the application is to file under order 22 on that other rule, order 22 is after when the plaintiff dies or one of the plaintiff dies. And go when one or when several
anyway, this is this I wanted to know, but No, but how is that? Just show me again. Page 23, yes, I've got. Number 3, substitution of parties. Order 22, rule 3, 4.
Next column. Under the heading or chart subject details under what rule?
Where are you? Subject detail.
Page 23.
Yes,
Chapter 4.
chapter 4.
Page general rules for application and ethics. Then there is a chart given.
Yes,
Or the headings. for
yes,
subject,
yes,
then details,
yes.
then
Under what rule? And whether affidavit missing.
So, when of party, under what rule power, what rule find under order rule 20, the order 22 and
Yes,
but application is find under order 23 or 4 printing whether it's the prediction of the
anyway, whoever wants to file, you file. I don't know. I don't know. Anyway. Correct.
but don't find that. I take that as paper. And I don't take the one to something. And there is no effect here. And you are you can also
Not to impede.
Obligation on my actually some people are on the that okay apply and it's the law is will get back to that that's how it's not that
Because it is in his interest.
because there's a money amount there's money there for him
Because even if this appeal abates, assuming now he'll have to execute, they have to file some execution petition or something for realization of that money. Correct. Unfortunately. Correct. 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 So that means your role is finished now. Because your since your client has expired. So once you have informed the court, then end of the matter.
Actually, right, right to survive, then we have to verify. Right, right, I was discussing. The law, the law applies. So if the law applies, I think I'm having something.
Correct, correct, correct.
For my.
So only thing now we will do is we will record his statement that the respondent number 2 has died, and that he will provide the information to you of the legal aid. That's all. Whether you implead on it, and okay. Just a minute. Item 53. Okay, right. What have I said? Ah. No, no. Now it'll be someone else. Mr. A. Sharma appears for the petitioner. Mr. S. Chakrabarti, learned counsel for the respondent number 2, submits that the respondent number 2 expire on 11/9/19. He further submits that he will provide the names of the legal heirs of the respondent number 2 to the counsel for the petitioner within 7 days. On the prayer of Mr. A. Sharma, leaves the matter after 2 weeks. Then in the other one, the date of death is 4/11/21. 4/11/21. What do you think he will do? At least yes, that is. Because if you file an impediment or a substitution, impediment comes substitution. Uh, I don't think there's any bar for this court to impede a substitute. Because we make our own jurisdiction, the court of record. And this is in the ends of justice, for the ends of justice. Anyway, the High Court rule says that, no doubt, but but whether the CPC order 22 will be applicable to writ proceedings in the strict sense. Yes, yes, yes. No, but then order, whether you see going deeper into it, okay, the High Court rules might say that, but whether the order 22 per se will be applicable to writ proceedings in this by letters. Correct. Then in that case, then suppose even if he has died, can't he still appear? No. That person, correct.
So, at your only that order is in favor of that. Okay. Then take a lot of other debate. And only when that's not going to that's like how. So I thought, well, I get that thing, but you get that thing. How was that thing? And the sentence of that is the respondent delivered.
The judgment has been passed.
Delivered. Right. There was reported before. Back. I was direct. It's from that clear. In fact, the respondent provide the legal day at the and the
नहीं नहीं